Section 810 of Canada's Criminal Code permits a person to seek protection when they fear, on reasonable grounds, that someone will injure them, their intimate partner or child, damage their property, or commit the offense of distributing an intimate image without consent. Unfortunately, sometimes politicians abuse this law to restrict the access of journalists who do not, in fact, represent any kind of threat and who are only performing the duties of their profession, which can include exposing wrongdoing by those in power. The court must be satisfied by evidence that the fear rests on reasonable grounds, not merely suspicion, discomfort, political embarrassment, or dislike of critical reporting. When that legal threshold is met, the court may require the defendant to keep the peace and be of good behavior for up to 12 months. It may impose reasonable conditions connected to safety, including staying away from specified places, avoiding contact with protected persons, or surrendering weapons. Section 810 also permits either party to apply later to vary those conditions. A peace bond is preventive. It is not a criminal conviction and is not supposed to punish someone for lawful past conduct. In 𝗖𝗽𝗂𝗋𝗄𝗧, the Supreme Court of Canada described the peace bond as an instrument of preventive justice. The court warned that a condition must be demonstrably connected to the feared conduct. Otherwise, it may simply set a person, who has not been convicted of anything, up to commit a new criminal offense by breaching an unrelated condition. Nothing in Section 810 expressly authorizes a justice of the peace to edit an article, redact a report, delete a video, or remove previously published information merely because an elected official objects to it. The section's only express reference to published content concerns the specific criminal offense of distributing an intimate image without consent. That narrow protection does not create a general power to censor reporting about government, public spending, or political conduct. The moment a court orders a journalist to remove lawful material, Section 2B of the Canadian Charter of Rights and Freedoms becomes central. Section 2B protects freedom of thought, opinion, and expression, including freedom of the press and other media of communication. That freedom allows journalists to investigate public officials, preserve the historical record, and give citizens the information required to judge those who exercise power over them. Freedom of the press is not absolute, but a court cannot restrict it merely because publication is inconvenient, unwelcome, or damaging to a politician's reputation. In 𝗢𝗽𝗽𝗿 v. Canadian Broadcasting Corporation, the Supreme Court overturned an excessively broad publication ban and rejected the idea that one legal interest automatically outranks freedom of expression. In 𝗖𝗽𝗽𝗿𝗀𝗃, the court refined the rule. A restriction must be necessary to prevent a serious risk to the proper administration of justice. Reasonable alternatives must be inadequate, and the benefits of the restriction must outweigh the damage it causes to expression and public access. In Toronto Star Newspapers Limited v. Ontario, the Supreme Court made the principle even clearer. The constitutional test applies not only to conventional publication bans, but to all discretionary court orders that limit freedom of expression or freedom of the press in connection with legal proceedings. In that case, an overbroad sealing order was quashed, with only the information genuinely required to protect a confidential source remaining concealed. The 2018 case of 𝗓𝗡 v. Canadian Broadcasting Corporation is particularly important when someone demands the removal of material already online. Even though that proceeding involved a statutory publication ban protecting a young victim, the Supreme Court did not simply assume that previously published articles had to disappear. The Crown was required to establish a strong legal case for compelling removal, irreparable harm, and a favorable balance of convenience. The court restored the refusal of the requested injunction because that demanding standard had not been met. What happens then when a justice of the peace uses Section 810 to impose an unrelated censorship condition? First, the decision may contain a reversible error of law. The condition may exceed the purpose of Section 810, lack a rational connection to the feared injury, be unreasonable, or disproportionately infringe Section 2B. A higher court may stay, vary, or quash the condition or order a new hearing. That does not, by itself, mean that the justice of the peace has committed a crime. Judges and justices sometimes make legal errors. Appeals correct decisions. The judicial conduct system addresses improper behavior. In Ontario, allegations that a justice of the peace acted with bias, improper motives, or political favoritism may be submitted to the justices of the Peace Review Council. The council cannot overturn the ruling, but it can investigate conduct. And in a sufficiently serious case, disciplinary proceedings can ultimately lead to a recommendation for removal from office. Criminal liability would require far more than proof of a bad decision. Evidence of deliberate, corrupt misuse of judicial authority could potentially raise offenses such as breach of trust by a public officer under Section 122 or willfully attempting to obstruct or pervert justice under Section 139. In 𝗖𝗽𝗂𝗋𝗋, the Supreme Court held that breach of trust requires a serious and marked departure from the standards expected of a public official, combined with an intention to use public office for an improper purpose. Mere negligence, disagreement, or judicial error is not enough. The consequences for the defendant are immediate. This is how corrupt politicians abuse the 𝗖𝗪𝗋 peace bond to silence critical media. If the journalist reports something the politician does not like, they only need to claim a breach occurred, such as by accusing without evidence that they saw the correspondent outside their house. Despite having committed no crime, the reporter is arrested based solely on the word of the elected official, who abused the purpose of the order and the authority of the justice of the peace to hold a stranglehold over investigative journalism, which might expose the politician's own unethical or criminal behavior.
Call the Barrie police, I need protection! That journalist is committing an 𝗖𝗪𝗋 violation.
Breaching a Section 810 recognizance is itself a criminal offense carrying a possible sentence of up to 4 years. That is why an objectionable condition should be challenged through an urgent request for variation, a stay, an appeal, or judicial review, not simply ignored. Section 810 gives the courts substantial power because genuine threats require protection. That power must remain tied to evidence, safety, and future harm. It was created to prevent injury, not to manufacture silence.